law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you determine whether or not you actually want to contact a lawyer. Perhaps we'll even help you to determine that you can handle some issues yourself. If you do decide to seek outside professional counsel, you'll be better prepared, and as a result, so will the professional you select. Our goal, of course, is to help you achieve the best possible results, save time and money. We want to also welcome and thank David Bazar, Attorney Bazar, from the Bazar law firm in East Providence, who continues to provide information and insights in each of our sessions. And today we're going to talk about auto accidents. We have previously covered this in the context of personal injury and some of those property damage cases. Today in this segment, details what you need to know about who is at fault, what depositions are, what combination cases are. There's some very interesting issues regarding who's at fault, what's fair, and what's really not at times. The recent statistics on automobile accidents is just, it's astonishing. 6 million average accidents every year, 90 die in car accidents every day, 3 million injured every year, 2 million experience personal injuries. These numbers are staggering. And of course, when they cite these statistics, also 40% due to alcohol, 30% due to speeding, 33% reckless driving. Not surprisingly, young people 16 to 19 seem to have more accidents than most, in fact, 3 times more than most. So there's plenty of things to cover. We've not covered the anatomy of what happens in an accident and what we should do. So you might guess, David, that the internet has its favorite things to do and not to do. But let's hear it from the lawyer.
Well,
what should happen?
There's a few different things, and you covered a lot of them. The one thing you didn't mention, which
Only
I think,
one?
Well, as far as causes of accidents more recently, distracted driving, which we might call texting while driving.
I think they're lumping that under reckless at the moment.
Well, it is reckless if you think about it, but it could be and should be its own category.
You're probably right.
You raised a wide open door for me to walk through, so I can take it in a number of different directions. And as we go through this a little bit, we can talk about how different states actually have different rules and different laws.
Yes.
But if you want to start with, I had an accident, I'm at the scene.
What happens?
And start from there. So obviously the first thing to do is call the police. A lot of people will have an accident, and if it's a very serious accident, someone's going to call the police probably for you anyway, but if you're able to, you call the police. You want the police to come to the scene to gather evidence, take as much information as they can. The police reports are generally pretty good. They're not always 100% accurate, and that's something we deal with down the road, but getting the police there to start the process is really important. Of course, if you're injured or someone else is injured, a medical response is really necessary and something you should do. I don't usually, depending on what kind of roadway you're on, highway for sure, recommend getting out of the car right there and trying to figure out, what's the damage, who did what. If you're on a highway, I would call the police and stay in the car until someone directs you otherwise for safety purposes.
So they say never, ever drive away from the scene. Does that make you automatically guilty if you do?
Well, it certainly will raise issues. And there are laws in most states, probably all states, against having an accident and leaving the scene. In fact, it's called leaving the scene of an accident.
Yes.
And it could be leaving the scene of the accident, property damage resulting, leaving the scene of an accident, personal injury, or serious personal injury. And that can be a felony if you have an accident and leave the scene with someone severely injured. It's criminal. So not only shouldn't you do it because of your civil case, you shouldn't do it because of criminal liability.
Good point. I know we always talk about how important it is to capture what happened on your cell phone if you're able to. You raise a very interesting point, David, when you say that if you were on the highway, be careful. That accident could be even compounded by another if you were to be hit. But if you were in a highway, should you not get out to try to take pictures? Should you not get out to see if somebody else stopped or talked to them? You should absolutely stay in the car if you're on the highway?
Well, it depends where on the highway and
Sure.
the situation and the flow of traffic and all of these other
Sure.
elements that you have to take into account. But I would say for the most part, if you're on a highway, a busy highway, a freeway, whatever we call it in this parts, you are probably safer waiting in the car until the police come. There'll be time for photos of property damage and that type of thing when the cars are either brought to the side of the road or some other safe place.
What happens to the witnesses, so to speak, or the potential witnesses? If you're both staying in your car, what are the chances that the witness, passerby, someone who is behind you, perhaps not hitting you, but just happening to see it, what are the chances they're going to stay? But if you were out, maybe you'd have a chance to snap their license plate or something? I don't know. Does that work, David?
Well, it's possible.
Not worthwhile?
It's possible. It depends on the type of accident, how serious it is, where it is. If it's a city street, for example, and you can get out easily, I would get out. I'd try to gather names of people who saw the accident or were there on the scene. Try to get as much of that information as you can. It's always helpful.
Does it make sense that you obviously want to, if you are going to get out of the car, you want to speak to the other person, check in, see how they're doing, of course, they might want to do the same of you. But is it more important to get to what might be someone who is on the street corner and possibly a witness who might like to beat feet and not stick around, but maybe you might want to go to them first because you'd want their name before they walk away and police come and it's another hour and a half or whatever?
Yeah, well, if you can get somebody's information, ask them what they saw, what happened, and write it down or type it on your phone or do something in the note section of your phone to keep that information. It's always helpful. It doesn't take a lot of time to just, if it's safe to do it, ask the other person in their car if they're okay, if they need an ambulance or help or whatever. I always think it's appropriate to care about
Yes.
other people.
Yes.
And so to ask how someone's doing and if there are other people in the car, how they're doing, if everybody's okay, to do that. And at the same time, if there is someone who witnessed the accident, ask them for help. Okay, can you help me for a second? Yeah, did you see what happened? What happened? See what they have to say, and if they've got information that's helpful to you, see if you can get their contact information, name, telephone number, whatever it is that they might be willing to give you.
And if it doesn't seem that anyone is hurt, do you advise that you go to see a doctor, if not go to a hospital right away? Do you think that that's necessary? Well, yes, ASAP, but that moment?
Sometimes if you're involved in an accident where you eventually feel the pain from the accident, but not right at the scene because of all the adrenaline and everything else that's going on.
Exactly.
I mean, you got to do what's right for you and your body. So if you don't feel it right then and there, and that happens, I don't think you necessarily have to go to an emergency room from the scene in an ambulance.
Yes.
If you're hurt and you feel it right at the scene, you should. But if you're just, yeah, I'm shaken up, but I think I'm okay, that's what happens a lot of times. But then that night or a couple of hours later when the adrenaline's out of your system and you're starting to feel your body again, if you're starting to hurt quickly or soon after an accident, I would go to an emergency room or a doctor as quickly as I can.
And what point do you call the insurance company versus, I know I'm going to need to call a lawyer? If someone's at a scene of an accident, you did it, no, you did it, you automatically know there's
a dispute.
A dispute. And how that elevates or not is a different story. But do you still call the insurance company first, even though you sense that this is going to be unpleasant? Or
your insurance requires you to report an accident to them in a timely fashion. And if it's not that day, by the next day you certainly should notify your agent or your insurance company directly that there was an accident, and they'll go through all the information with you. So that's why it's good to gather all the information. Sometimes you won't have a police report when you call, so you can only give them the information that you have, and it can get supplemented later.
when each is giving the report to the police, I'm thinking that rare would be the occasion when those two reports would sync up completely, especially if you think that there is a dispute or you hear that there's a dispute. So it's an issue about whose truth.
Well,
What's the truth?
Sometimes what happens is there's no dispute. I'm stopped at a
Yes.
red light, I got rear-ended. The only issue by the person who hit me from behind might be the reason why they did it. It really usually doesn't matter why they did it, but they'll tell their story, you'll tell your story. And they'll probably match up more or less.
Yes.
There are times where they don't match up.
Yes.
And so you, as an attorney or a police officer, may even look at some other facts that might help support one side or the other. For example, witnesses. If we have a intersection controlled by lights, there may be witnesses who saw, well, I was standing here and I saw this light was red, yellow, green, whatever, and someone might have been on the other side and saw something from that side. So if you have an independent witness, as a police officer, they should, especially in a contested type of situation like that, try to gather as much information as they can. Points of impact and damage to vehicles might be helpful information in determining what happened, and skid marks could help determine.
Sounds right. So if you contact your insurance company, you've been to the doctor, you're not sure what else is going to have to happen resulting as a result of this, at what point do you know that you really need to have a lawyer other than we're having a dispute here? I say you did it and I say I didn't do it or whatever. When do you know that you have to call a lawyer? I'm thinking that an insurance company, certainly they're paid to insure you, but not necessarily is that amount the reasonable and correct amount, et cetera. So
our clients will, if they're injured, will, whether they know it's 100% the other person's fault or a dispute, will call us right away. Usually after they've been to the doctor and they've got the police report and all that information. But the insurance companies will start contacting you, and many of my clients will say, I don't want to talk to the insurance company because they may take words that I say out of context or change things, and so I just want you to deal with that for me, and so they come in right away.
So at that point, when the insurance company calls, they'd be saying, Mr. Jones, please call my lawyer instead?
Well,
or would they still want your information
if the
from
insurance company
you?
calls Mr. Jones, and Mr. Jones has a lawyer, he should tell the insurance company, I have a lawyer, this is my lawyer's name.
And you would then have heard the story from your client, taken the information down as
Right.
he presents it?
Sometimes. Sometimes the insurance company will have called them before they actually came in for the appointment. And when they call me, I'll say, I have an appointment to see my client. I will give you all the information you need after I speak to my client.
How long does that usually take after the insurance company's been notified?
For them to
Come
contact
to you?
to me or to
Come to you.
Well, they won't come to me until they know that I'm involved in the
Right.
case.
And once they've heard, you'll have to talk to Mr. Bazar.
They'll usually call me right away, and I'll respond if I have information right away. I will have already sent them a letter of representation. If my client has already been in to see me, but otherwise, if they haven't, I will do exactly what I said, which is I'm gathering information. When I have enough, I'll contact you.
So someone might contact a lawyer because they've already heard that there's a dispute, or I have no idea how much compensation I really should have out of this. I don't know what the ultimate medical damages will be, never mind how much my car needs to be repaired or if it's totaled. You would know those kinds of things or have a gauge that you'd be able to say to them, based on what I see right now, yes, you might have a case, or might you say, no, you don't?
Well, certainly whether they have a case or not, there's many components that go into determining that. Whether or not there's a liability issue, which is what you're talking about, where
Yes.
they're pointing fingers at each other. If, in reviewing all the information that we have, we can determine that it's either potentially what's called a comparative negligence situation,
Yes.
which is there's some fault on both sides. And if it's Rhode Island, for example, it's pure comparative. So you can be more than 50% at fault and still recover that percentage of your damages that the other driver's at fault. Massachusetts is not a pure comparative negligence state. So they have contributory negligence. And so if you're more than 50% at fault, you don't recover in Massachusetts. So it depends where the accident happens. We have clients call us for accidents. I have lawyers in my office who do both Rhode Island and Massachusetts. So we have to know where the accident happened to determine what the rules are that are going to apply. But for the most part, you have to look at liability first, and then you look at damages. So if someone comes in and they are complaining that, well, for example, I have a broken arm and I've got to go through treatment and I can't work because I'm a carpenter, those are all factors that go into assessing damages. So to have a recovery, you have to have damages and liability or negligence on the other side, and a causation between your damages and what they did. So you have those things and they have coverage with an insurance company, an attorney is going to take that case.
So you brought up a moment ago the difference between, say, contributory or comparative. How does a judge determine who's 51%? And in the state where you need to have 51%, that determines what you will and won't get. How does someone determine it's more than 51, or it's more than 50%, it's 51%?
So technically,
yes,
that's a factual determination
okay,
that a jury would decide.
Okay.
Judge decides the law, jury decides the facts.
Okay.
But it could be an arbitration, so the arbitrator would decide that. It could be mediation, which you're just going to let the mediator argue back and forth to both sides. But long and short is, if it's not in suit and you don't have to wait for a jury to decide the case, it's something that an attorney can dispute and argue with an adjuster over.
I see. So backing up a moment, we said at the top of the segment, sometimes there's a thing called a deposition required. At what point and what are the circumstances? How does that play out? When is there a deposition and what's involved?
So a deposition wouldn't happen until you've gone through the process of trying to settle a case, not being able to settle the case, putting the case into suit, and now reaching the discovery phase of that lawsuit, which would be interrogatories, written questions, which can go back and forth between the parties, and depositions, which are sit down, stenographer, lawyers, you ask questions, the stenographer records the answers and the questions, and it's part of discovery.
So in a deposition, would each side be at the same table but at different times?
Yeah, no, same time.
Same time.
The lawyers and whoever's being deposed is at the table at the same time.
And then what about the second? Is the other person
Those depositions are usually set up separately.
Separately.
Parties do have a right to be at a deposition of other people. Doesn't usually happen, but they have that right.
When it comes to those depositions, it makes sense. What's your name, rank, and serial number, and things that are absolutely tied to the case. As I took a look at the number of questions and the kinds of questions, it was very interesting to me. So, for example, if we're talking about an auto accident, which is what the topic is today, why would they be asking about my criminal background and whether or not I've ever been convicted of a crime when, in fact, so-and-so hit me or I hit so-and-so?
So usually for discovery, you're allowed to go a lot more broadly than you would be able to delve into questions at a trial. So your past criminal history probably has no relevance, but it could, in the sense that, what was your criminal history? Did you have a criminal history of dishonesty and fraud? Do you have a criminal history of filing false insurance claims?
They did ask, so if you ever filed any lawsuits, so that might be very relevant.
It could be.
Could be.
It probably, really, for the most part, usually isn't, unless they're able to establish some kind of nexus or pattern to what you're doing to try to, it really goes to your credibility. And so if they want to attack your credibility, that's why they usually will want to know about those things in your background.
And they might say, so how did you feel before the accident? What was your health, the status of your health or your condition beforehand? I think that to some extent gives you a context.
Right.
Would someone reasonably be expected to answer that in all cases when there's an auto accident?
If you have an auto accident where you have a claim for personal injury, you're putting your health in issue. And when you do that, they're entitled to know, okay, so you have a claim for an injury to your knee. Well, 2 weeks before the accident, you had an MRI on your knee. So what was going on with your knee before the accident? Did the accident make it worse? Did it cause the problem? Why are we here? So actually, sometimes it's been helpful where somebody had an MRI, say, of their back, and the MRI didn't show anything. And then a month later, there's an accident, and new MRI shows a herniated disc. Well, now it's actually very helpful for you that you actually had a little back pain before, but you were dealing with it. The MRI didn't show anything, and now immediately following the accident, we have a much different situation. And of course, the reverse can be true. That herniated disc was there prior to the accident. Yeah, maybe this exacerbated your pain a little bit, but
it didn't cause
it. Didn't cause it.
So, considering that a deposition doesn't happen day 2 after the accident, usually.
Right. Definitely not.
By the time someone is doing deposition, and it makes sense that you want details then of how the accident happened, and someone is saying exactly which driver did what, at what time and when, if time has passed, how accurate can that record be?
Yeah, it depends on the person who, and their memory and what they're trying to do.
So if they're asking specific times when something happened, the specific distance, how far away was this car from that or that passenger from the other, those kinds of things seem to, unless you, and do you, have someone write all of those things down right then and there when they see you, maybe day 2 after the accident, but if it's months down the road, that picture could look different.
When my client comes in to see me, we take detailed notes on everything that happened, who said what did they do, where did they go. So we have a record of it. There's also a record of a lot of it in the police report.
In the police report.
So when we meet with our client to either answer interrogatories or to prepare for a deposition, we go through with them. And if I don't remember what day of the week the accident was, well, here's the police report. Does that refresh your recollection?
And that's fair?
Of course, you're allowed to look at notes and other documents to help you remember things.
And of course, if at the scene of the accident you happen to get out of the car and say, oh, I'm sorry, are you all right? We've talked about this topic of never say I'm sorry or say I'm sorry. If you say I'm sorry, I'm so sorry that you're hurt, I'm sorry that this accident happened, does that end up being held against you and as admission of guilt in an automobile accident?
It depends how you say it, and it can be, if you got out of the car and said, oh my God, I shouldn't have been texted, I don't know why I was doing that.
Yes.
And I was just finishing the text when I look up and you were there. That is probably going to be used against you.
That's an admission of guilt right there, certainly.
I would think so. But if you got out of the car and you said, are you okay?
I'm so sorry this happened.
Yeah.
Is that an admission of guilt?
It's getting closer, but it's maybe not quite there.
It really does. I can tell you of all the things that we've read, I know we've talked about with the James Wood case and Kent County Hospital, and he took some compassion on the director for her having said, I'm sorry.
Right.
And in this case, or some of these cases, if you say, I'm so sorry that happened to you, to know that it's on an equal par with perhaps admitting guilt means beware. Would you tell your clients, make sure that you're, well, of course, you tell your clients in a deposition, be accurate as you can, don't fib.
Right.
But would you tell them or ask them whether or not they admitted or said, I'm sorry? Do you ask them about that?
I ask if there was a conversation at the scene and what did everybody say? Because I don't only want to know what they said, I want to know what the other party said.
Yes. So what happens after a deposition? I understand that some, but not all evidence is disclosed at that time. How does that play out, David?
Well, I'm not sure what you mean.
So if, what evidence might there be? Someone had photos on the cell phone, didn't show it to you. Well, if you're defending them, you would, or whatever.
They can't access them, and they say, oh, yeah, I have pictures at home. And yeah, so if they're discoverable, you can say, we'll send you a copy of those after that's happened.
Okay.
But for the most part, before the deposition is taken, the other attorney's already been sent everything that you have. So
there's no surprises at the day of if you end up going to court?
We don't do Perry Mason trials anymore.
That's good to know. So what else what else actually happens after that deposition? And it's transcribed, you get to review it?
Yeah,
what else?
So the deposition transcript comes in, you can review it with your client. In some states, they make you sign it that it's accurate. Other states you don't do that, but if there are corrections, you can send the corrections to the stenographer and ask that they be made. But pretty much after the deposition's done, it's either try to settle the case or move to the next step, which might be arbitration, mediation, or trial.
And once you've seen the other's deposition, does that help you to determine the strength of your own case, or help you decide whether or not you want to settle it versus do the knockdown drag out in a court of law?
It can, and usually it's more helpful to the defense attorney who's deposing your client, and because usually the issue is over damages.
Yes.
Pretty much we've already agreed, not always, but many times, on who's at fault. And the defendant, if the defendant's at fault, and it's a damages only case that's really at issue, the defense lawyer gets a chance to see your client, assess their credibility, assess what how the jury would feel about them and what they're having to say, whether they exaggerate injuries or don't, that type of thing. So that's one end of it. And if there is a liability issue, they'll again assess credibility and whether or not your client's going to be believable. And of course, you can do the same if it's a liability issue as to what the defendant has to say.
How does this change if it's not just he said, she said, but perhaps he said and it happened to her while she was working, and now you're looking at, is it workers' compensation? Is it personal injury while they're on the job? What did they file for? How does that nature of that case then
Is that what you meant by combination injury at the beginning?
Well, why don't you tell us about that, David?
Yeah, I don't call it that, but you could have a client who, let's just say, for example, is a visiting nurse and is going from one home to the next. And if they get hit by another driver who's at fault, rear-ended at a red light, they could collect workers' comp, so it's a workers' compensation claim.
Yes.
And it's also a third-party case, as we would call it, or a claim against somebody other than a co-employee or your employer who caused your injury, so that you can collect for the auto accident end of it. But there's an offset for what workers' comp paid, so you don't get a double recovery.
So you really do look at whether it's workers' comp, personal injury, and whether or not there's another factor in there, namely a third party who is involved.
Right.
So I understand that there are an awful lot of lawyers who are very interested in these kinds of cases. Does this end up being magnified even more if it ended up being a semi-truck, for example, instead of two cars?
Well, I mean, that would go to the credibility maybe of the injuries. If a little car hit another bigger car, sometimes people have a hard time understanding the dynamics of that and how an injury can occur, which it can. You know, it's where are you looking in the car? How's your head turned? Because are you at a more vulnerable position? Whereas people might understand that a semi-truck, is that what you said?
Yes.
Hitting a little Volkswagen bug and squashing the bug might cause more serious injury to the person in the car.
Good to know. Well, we hope that this has been helpful to you in terms of the things that happen as an auto accident plays out. Of course, we hope that that never happens to you, but we thank you for tuning in to The Law Matters, because as we say, the law matters to you.